Good afternoon, good evening, potentially good morning, everyone. Welcome to the School of International Relations seminar series, this time hosted very proudly by the Center for Global Law and Governance in the School of IR. My name is Dr. Adam Bauer. I'm one half of the directorship at the CGLG. My colleague, Dr. Peter, is feeling just a touch under the weather, and we thought, just for the purposes of clarity of voice, it would make sense for me to step into her esteemed shoes to chair today's session. So get well soon, Matea. We're really delighted, both Matea and I and the entire CGLG and indeed the entire School of IR, we're delighted to be welcoming all of you to this conversation and to our special guest, whom I'm going to introduce in just a moment. Before I do so, let me just run through quickly a couple of the logistical points, which I'm sure are familiar to everyone by this point in our Teams and Zoom decade, it feels like. If you don't mind, please keeping your video cameras and your microphones off during the session. That allows us to preserve bandwidth, but also make sure that our speaker is the focal point for the discussion. Secondly, as you know, the session is being recorded and a full version will be available on the CGLG website soon in the coming days. And lastly, after Professor Terhechte's lecture, we're going to have time for Q&A. So I'd really encourage you to think of questions that you might wish to pose, and you're welcome to do so by posing those directly into the chat function, which I'll be moderating. So you can see that at the top of your screen. For those not familiar with Teams, there's a small chat bubble. Feel free to pose your questions at any point during the conversation. I will be moderating the subsequent Q&A. If any of you are on the call and are unable to type for any reason, you are welcome to raise your hand and I'll call on you for a video intervention. But just for our own logistical purposes, it's easier if we can keep as many questions in the chat function as possible. So thanks so much for your cooperation in that regard. Lastly, let me just briefly introduce our speaker before I hand over to him. So many of you will have had the chance, I hope, to have engaged with Professor Jörg Philipp Terhechte's work, and you should also know by now that he is currently visiting professor with us in the Center for Global Law and Governance and hosted in the School of International Relations, and is a corresponding member of the Institute for Legal and Constitutional Research here at St. Andrews, and we're really delighted to be hosting him through 2021 and 2022. So since 2012, Jörg is Professor of Public Law, European and International Law at Leuphana University in Lüneburg, Germany, and was elected Vice President of that university in 2016. In 2018, he was also appointed Professor for European and International Economic Law at the University of Glasgow, so he has another Scottish connection that we're really pleased about. And Jörg has held visiting positions in Barbados, Beijing, Cape Town, Oxford, St. Petersburg, and Washington, D.C. The title of Professor Terhecht's talk this evening is The Future of European Constitutional Law After Brexit. And of course, this is a really timely and important topic, and we're really fortunate to be hearing from such a recognized expert on the subject. This lecture also marks the first public event of Professor Terhecht's tenure as a visiting professor, and we're looking very much forward to hosting further events into 2022, and we'll be advertising those in second semester once we get back after the winter break. So that's just about all the preliminaries from me. Jörg, we're delighted to have you here. Thank you for joining us. Thank you for participating with the university over this period of time. We look forward to the lecture and the Q&A to follow. Now, I'm going to be sharing the screen, so if you'll bear with me just one moment, we'll get that up and running, and we will be off to the races for the lecture. So, just one moment. Just loading briefly with the usual technical considerations. That should now be visible. Can I get a confirmation from you, Jörg, that you're able to see that okay? Excellent. Well, sir, the floor is yours. Professor Terhechte, we're really glad to welcome you. Please, welcome.
Yeah, thank you very much, Adam, and I'm delighted to be on board, and I'm very happy that we can discuss, I would say, a very important topic today, the future of European constitutional law after Brexit. And just a few words of my background. I worked in international law and European constitutional law in the last years and published, especially in Germany, a couple of books on the question whether we need or should have a European constitution and why constitutional thinking and scholarship in Germany, but also in Europe, is in decline at the moment. And of course, today I want to discuss the relationship or the consequences of Brexit for European constitutional law and European constitutional law scholarship. So that is a little bit the idea, and I have an agenda on the next slide, which deals with the main topics I want to discuss with you. First of all, the idea and concept of European constitutional law, which is, of course, seen as a very German discipline. So if you read some books and journal articles on European constitutional law, you can, especially from some colleagues in the US, but also from the UK, you can read it's a German discipline. Yes, it is. And I want to explain why it is a German discipline, but also why it is important to discuss the important questions of the European Constitution. I want to, after that, I want to concentrate on early concept and drafts of the European Constitution, so the beginning of constitutional thinking, and especially the early jurisprudence of the European Court of Justice, today the Court of Justice of the European Union, but it's the same institution, and especially the German Constitutional Court. So as you know, Germans like the Constitutional Court, and it is a very important institution in our constitutional life. And it is, of course, maybe the most important court in Europe next to the European Court of Justice and the maybe the Strasbourg Court. After that, I would like to discuss a lesson of failure, the draft constitution and the constitutional drama between 2002 and 2005. And then I want to ask the question whether Brexit is just another constitutional setback and what Brexit means for the European constitutional law scholarship, but also for the project or idea of a European constitution. And of course, we'll finish with some conclusions and an outlook. Well, on the next slide, we see that Brexit and what I would call the decline of the concept of European constitutional law, there is a relation. And this relation can only be understood, or we can understand this relation if we just focus on the whole constitutional narrative from the last 20 years. And well, maybe it's just another rise and fall story, but I think it is much more than that. And if we discuss in this context some important steps, I would start with first ideas, the Laken Declaration, we go into details later, the draft constitution, the constitutional approach after 2005, and all the problems we face at the moment. So Brexit, the rule of law crisis within the European Union, so the discussions and also battles between the European institutions and some member states, especially Poland and Hungary at the moment. We also would have to discuss national resistance when it comes to the implementation of European law, and of course the financial crisis. So there are many rise and fall stories out there. And the final question for me would be, is the conference on the future of Europe, which is now working since 2020, a good answer to all those polycrisis, as Jean-Claude Juncker named the whole situation, characterized the whole situation. So the idea is a little bit now to bring together Brexit on the one side, the concept of European constitutional law, and to try and to discuss the historic context of all what happened in the last years and what will happen. And if we talk about European constitutional law, especially in Germany, many scholars would say this is not self-evident, especially not when it comes to the European Union. The Union is not a state. Why do we talk about a constitutional approach? Why makes it sense? Why do we talk about a constitutional approach in international law? Isn't a constitution just well, the legal order of a state? So the next question on the next slide would be, what is a constitution? And here is a very famous quotation of Lawrence Tribe. Lawrence is a professor for constitutional law at Harvard Law School, and his famous textbook on constitutional law is a global must if you deal with constitutional law. And Lawrence Tribe says, well, how much can be gained by seeking any single unitary theory for construing the constitution is unclear. It may be that all effort at such reduction or simplification, however legislative, are ultimately more misleading than informative. For the constitution is an historically discontinuous composition. It is a product over time, over a series of not altogether coherent compromises. It mirrors no single vision or philosophy, but reflects instead a set of sometimes reinforcing and sometimes conflicting ideals and notions. So it's pretty much unclear what the term and concept of a constitution is, and because of this, European law scholarship started very early, I would say in the early 70s, to discuss whether the European agreements or treaties form of a kind of special constitution or embody constitutional documents. However, it's complex, and just to say it's maybe a constitution does not mean it is a constitution. Because of this, a functional approach became very popular. And on the next slide, we see some elements of such an which would characterize such an functional approach. So a constitution is seen as the highest law of a community or a sovereign state. From a more traditional perspective, it would always be the highest law of the state. And constitutional texts deal with, for example, the separation of powers in a community, in a state, deal with institutions, maybe with the lawmaking processes, especially the traditional constitution and concepts in the United States, but also in France, later in Germany, focused on democracy, of course, and the democratic process. And of course, with fundamental rights, which is, of course, another important cornerstone of most of the constitutions we know. Another element which is very prominent and important is this idea that a constitution should serve and should help to integrate a society. So bringing together people would be another important task of a constitution. And well, if we now would start to analyze the European treaties, we could find many arguments that they have a kind of constitutional function. Of course, there is not a separation of powers. We call it institutional balance in the context of European law between the European Parliament, the Commission and the Council. Of course, the EU Treaty and the Treaty on the Function of the European Union provide for many information what institutions do we have and how the lawmaking process is organized. I mean, in fact, lawmaking is one of the most complex questions in the context of European law. Especially the Lisbon Treaty added some new articles dealing with the democratic life in the European Union. And of course, the Charter of Fundamental Rights is a binding document today. And now we could discuss, is this document or are the two documents, the Treaty on the Function of the European Union and the Treaty on the European Union, documents or constitutions, do they help to integrate the societies, the different European societies? Well, some scholars would say, no, we talk about different societies, different countries, different cultural backgrounds. However, in the late 90s and starting in 2002, a very interesting constitutional debate started, not only in Germany, but all over Europe. And on the next slide, you will find two important definitions why we could transfer the concept of a constitution to the European level. So Armin von Buck-Dundee here in Germany and Jürgen Bast in their famous constitutional law, European constitutional law textbook said that there are good reasons to treat the European Union current primary law as constitutional law. After all, it establishes public power, legitimates legal acts, provides a citizenship, protects fundamental rights, and regulates the relationships among legal orders as well as between law and politics. This is more a legal definition, a legal argument. Jürgen Habermas, one of the famous German philosophers, just had a different approach, saying that in the face of a politically unregulated rise in global society complexity, which systematically and increasingly restrict the autonomy of a nation state, the normative function of democracy itself requires that political agency be expanded beyond national boundaries. So, two, I would say, interesting quotes here on why we need a European constitution and why we could well, characterize the European treaties as a constitution. And that is, of course, not a new insight. So both books were published in, I would say, between 2006 and 2007. But from the very early days of European integration, the question, the constitutional question, was a very important one. And on the next slide, we see that it's very interesting in the context of European constitutional law and Brexit, that it was, of course, Churchill, as you all know, the famous speech in Zurich, and the idea we need something like the United States of Europe, but, and this is pretty interesting, of course, without the UK. And if you read early policy papers, documents, textbooks on European law, early commentaries here in Germany, it was always about this idea we need something like the United States of Europe. It was a dream which was inspired by all the experience we made with 2 world wars, of course, and it was, well, something like the founding period of Europe. And this was pretty interesting, a pretty interesting period. If you read, for example, the Coal and Steel Community Treaty, this is a very political, far-reaching document. If you would compare the authority of the or the competences of the high authorities at these days with the authority and competence of the European Commission today, you will find that in the early days of European integration, the today's Commission had much more power. It's pretty interesting, and the supranational character of this community was in comparison a far-reaching new concept. So it was something like a period for political reasoning, for some interesting drafts. But after a couple of years, there was nothing like a discussion about the constitutional character, and there was no constitutional pathway anymore. And we call this period of functional integration. And well, in the next 20 years, I would say you won't find too much discussions about a European constitution or something like the United States of Europe. And in the early 80s, it was an Italian former communist, Altiero Spinelli, who published a draft constitution for Europe. And this was even accepted by the European Parliament in 1984, but the head of states of the member states, of course, rejected this and said, well, this would need more time. We have to think about this. But it's interesting to see that that the idea, the constitutional narrative, was always part of the European discourse. So it's not a new fancy German idea or something like that, but it's an inherent dimension of the European Union, and it always was, and that's why we should discuss it even today. The Court of Justice of the European Union launched some interesting judgment. We'll talk about this in a few moments. And of course, after the reunification in Germany and the fall of the Iron Curtain in Europe, we had a discussion about the future of the European Union. And part of this discussion was, again, the constitutional discussion. And that's why more than 15 different draft constitutions were circulated, starting in 2000 until 2005. You could say this was the time for constitutional thinking. The European law scholarship scenery was dominated by constitutional journal articles with a constitutional approach and so on. This was a pretty interesting, innovative time for European legal scholarship. And of course, it was not only a dream, but some courts made the European Constitution a normative project. It was not just a description of what could potentially happen, but especially the European Court of Justice, but also the German Constitutional Court, even earlier, the German Constitutional Court, worked with this constitutional slang, to say it like that. So in the next slide, you will find a citation of the European Court of Justice from 1986. And in this very important judgment dealing with the role of small parties in the European Parliament, the court found that it must first be emphasized in this regard that the European Economic Community is a community based on the rule of law, inasmuch as neither its member state nor its institutions can avoid a review of the question whether the measures adopted by them are in conformity with the basic constitutional charter, the treaty. So here you find a direct link between European constitutional law and the jurisprudence of the Court of Justice. The court characterizes the treaty as a constitutional charter. And even in 1967, we tend to forget this in the legal discourse sometimes, the German Constitutional Court found that the EEC treaty is, in a sense, the constitution of this community, and this community is, of course, the European community. So this constitutional narrative, this constitutional approach is not only based on fine legal scholarship, of course, but also on some judgment of the constitutional courts in Europe, the Court of Justice and the German Constitutional Court. But it was maybe too innovative, too dynamic, because after those judgments, after the initiatives of Spinelli, after the fall of the Iron Curtain, it became evident that Europe needs, or the European Union, the European communities at these days, would need new dresses, as Joseph Weiler once said. And the idea was to work on a constitution, a draft constitutional treaty. And it's pretty interesting because the starting point was the so-called Laeken Declaration. Next slide, please. In 2001, there was the famous meeting of the head of states in Laeken, which is a suburb of Brussels. And if you read the conclusions of that meeting, it's pretty interesting. I have it here because exactly on 15th of December, 20 years ago, I would say the most important initiative in the context of European constitutional law was launched. So the Laeken Declaration contained a clear mandate for a European Convention to draw a European constitution. So it was a clear result of what happened in the years before, of course, but if you read the presidency conclusions and the Laeken Declaration, it is somewhat interesting because the sound is not the sound of an old document. You can read it today and you see we deal with the unfinished business. So a European Convention. It was chaired by Valéry Giscard, former president of France, and some other politicians, but also members of the national parliaments, high-ranking politicians, and so on. And they worked on a draft. And the idea was clear, something like a constitutional, we need something like a constitutional document. So one document, not some different treaties. Remember, these days we had the Treaty on the European Union, still the Coal and Steel Community Treaty, the European Economic Community Treaty, and Euratom. So 4 basic documents, a complex structure of the whole Union and of the interaction between the Union and the communities. What was unclear, the question was, has, for example, the European Union legal personality or not, and so on. So we had a lot of not only legal problems, but also political problems because of the complex architecture of the treaties. So the idea was we need one document and one legal personality. And it should be something like a constitutional treaty. Well, I can remember that I was a very young assistant professor and I had a conference at Georgetown in Washington, D.C. And I was very proud, of course, I was a European who had to present the results of the European Convention. And I was a little bit disappointed because my American friends were very critical. They said, well, this is a constitution, 448 articles, a constitution which contains competition law, chapters on tourism, chapters on agriculture, chapters on energy, and so on. Why do you call it a constitution? It's just a collection of different legal traditions and so on. But is it really a constitution? So it was an interesting debate at these days. And the draft constitution, of course, combined different ideas, to say it like that. On the one side, those technical aspects and technical norms and competition law and so on, but also those typical state rhetoric, right? Symbols, a European flag, an anthem, and so on. And of course, from a lawyer's perspective, very important, a clear rule on the relationship between European law and national law, domestic law. So this constitution had a clear vision. European law is supreme, this doctrine of supremacy, which was based on the jurisprudence of the Court of Justice, would have been transferred to the constitution, to the written law. But as we all know, this draft constitution failed because of the negative referenda in France and the Netherlands. And well, it's interesting to think about what would have happened in the UK because of the negative referenda in France and Netherlands. The UK never ratified the draft constitution. The whole process was stopped. That was a first attempt, and here are some lessons to learn for our future discussions, I would say, and of course for the conference for the future of Europe we witness at the moment. So that was a dramatic lesson of failure, to say it like that, a dramatic setback for the idea of European constitutional law, of course, not only for the constitution, but also for constitutional law scholarship. You will find hundreds of journal articles between 2002 and 2005 dealing with European constitutional law, the idea of the European Constitution, and all relevant discussions you would expect. After 2005, 5, I would say the topic is not that popular anymore. So the next today we deal with all the crisis with Brexit and so on, but you won't find too many publications dealing with the concept of European constitutional law and European constitution. Well, having said this, now it's interesting to think about what does Brexit mean in this context. And the next slide offers some ideas how we could characterize Brexit in the context of European constitutional law. If you would like to have a very optimistic view, I could offer you the idea that Brexit could be something like a special constitutional moment. You know, maybe you know this theory of constitutional moments, which was developed by Bruce Ackerman. So the idea that Brexit is a constitutional moment for the European Union, but also for the United Kingdom, of course, because after Brexit, and I think we have many experts here around, you could discuss what the future of the UK is. Doesn't the UK need a constitutional debate? What about the union within the UK? And it's also maybe a constitutional moment for the European Union, because many people said after Brexit that now it's time to go on, right? We have to learn our lesson and have to work on a new constitution without the UK. Well, I don't think that this interpretation is a very good one. Another, well, constitutional aspect of Brexit is, of course, the role of the British Constitutional Court now. You know, all the judgments. So the Brexit caused constitutional disputes in the UK. That's another facet, maybe another constitutional setback. And maybe Brexit is also a result of the failure of the draft constitution. Because the draft constitution introduced for the first time the right to withdraw. There is what I call here a strange equilibrium between eternity and leave, if you read the text of the draft constitution. And this is, of course, today the text of the Treaty on the European Union. On the one side, Article 53 of the treaty says that the treaty is concluded for an unlimited period. This is a very old provision, and of course the background is that the coal and steel community treaty was concluded for 50 years, and the EC treaty and the Euratom treaty for an unlimited period. The idea was really, if you read the old commentaries on EC law, a withdrawal is not possible. That is a typical German argument, of course, and a typical argument of maybe French scholars, but you won't find something like this in the English literature dealing with European law. On the other side, so concluded for an unlimited period, it was the idea for we have to stick together for the next 1,000 years. We must create something like the United States of Europe. That is a clear background of Article 53. It's much more than such a provision dealing with the duration or the time limits. It's really a constitutional provision with a clear background and telos. On the other side, Article 50 was introduced. Any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. The background of Article 50 and the intention of the member states is pretty much unclear. If you talk to some politicians, they would say, at least they had the idea we need a kind of fallback option for political disputes. The idea was if some member states would not agree to next steps in European integration, we could always say, okay, then leave. So it's more about political pressure. It was not seen, I would say, as a realistic option for politics. And that was, of course, in the context of Brexit, maybe a mistake. However, it's disputable. Would Brexit have happened without Article 50? Well, I don't think from a political perspective that this is a good argument, but however, we could discuss this point later. On the other side, and we see this on the next slide, we have a debate now that Brexit can be seen as a push for European constitutionalists. It was, I think, Joe Weiler who said that there always was a kind of split between the UK and some European countries within the Union. For the Germans, for the French, for the Italians, the European communities were not just a project or a free trade agreement or something like that. It was a community of faith, and maybe it is a community of faith until today. And for the UK, it was a kind of deal called, I think I call it a deal mentality. So what's in for us was the question. It's of course a legitimate question. It was a legitimate question, and it still is a legitimate question. So, but now after the withdrawal, so after Brexit, the idea is that now we have a community of states with the same intention, background, ideas, right? Well, that is disputable, I would say. I don't see the same intention in Poland and Germany at the moment. So is it based on faith in all Eastern European EU members? I don't know, just to say it like that. But it's interesting to see, of course, the member states of the European Union have different ideas and vision what the Union is about. And it's, by the way, interesting, you won't find any paper or book dealing with the concept of union in this context. So in fact, we don't know what union means. And so every state has a different vision, maybe, what a union means in this context. So on the one side, a community of faith, on the other side, a more deal approach, what's in for us. Well, I don't see that Brexit pushes any constitutional ideas at the moment. The opposite, I would say, is the truth. And maybe Brexit adds a new facet or is a new dimension, means a new dimension for European constitutional law. First of all, of course, European constitutional law has to deal with the new trade and cooperation agreement, the TCA, which is an international agreement, and according to Article 216 of the Treaty on the Function of the European Union, is not secondary law, but not primary law, but in between. So it has a very prominent position, but it has to be interpreted in the light of well, all the methods we know and in the light of the treaties, but also in the light of international law. That is pretty interesting, and we have to deal with it. The TCA is not a constitutional document. It's not a constitution, and we shouldn't treat it like a constitutional document or something like this. It is more, I would say, that we have to work on a new, what I call a EU-UK relations law at the moment. The TCA is a very complex document, hundreds of articles, and it is very important to focus on this at the moment, even for constitutional lawyers, because this new EU-UK relations law could be very interesting. And it's, of course, very important because it touches our everyday lives, especially mine, of course, in the travel between the UK and Germany. So we need a clear theory, a clear institution, theoretical setting for this new relations law, because it is still a difference. You could say, well, it's international law now. But is it true? We talk about the relation between a former member state of the Union, a former member state with tons of legislation, which is in line with EU law still and will be for sure in the next decades, with the same approach when it comes to human rights, the same understanding how political institutions should work, and so on. So it's, from my perspective, it's much more than just international law. Although the TCA refers to international law in many provisions. So that could be very interesting, and I hope to discuss this with you later, what this could mean from a political perspective, but also from a legal perspective. So we have to invest much more time in the TCA. It's, from my perspective, much more than an ordinary free trade agreement between two partners. Well, on the next slide, we see now what this whole development means for the future of European constitutional law. So it is interesting. It's a discipline. It's a scholarly approach which has to deal with substantial setbacks and problems. We had a draft constitution, it failed. We lose members in the Union. We face substantial crises in the last years. And what is now the answer? Well, from a constitutional point of view, you would say, well, maybe we need a kind of new document which brings together politics and law again from a new perspective, a new beginning. We need a discussion about European democracy. We need a discussion about the participation of the next generation, maybe, and so on. But what was the answer after Brexit, in the context of Brexit? One answer of the European Commission was a flood of 5 white books. Technical documents, and I have to say, without any resonance so far. In the white books on the future of the European Union, but also on the future of the monetary union and some other important parts, the Commission preached a new religion, to say it like this, flexible integration. So every white book contains different scenarios dealing with ideas what could happen in the next years, between setbacks, standstill options, and of course the idea of flexible integration as the next important instrument and tool of European integration. I don't believe in flexible integration so far. I can't say why. We have 4 or 5 examples. The euro is one story, but all the other legal acts based on flexible integration, on the concept of flexible integration, just demonstrate that member states were not able to find a common approach. This applies to a patent regulation. This applied to a regulation dealing with family laws. So there was a substantial dispute between the member states. And so flexible integration is not what the Commission wants to say, or what intends to do with it. It's so far as I would say, it is just it underlines political disputes and problems. And because of the technical character of the white books, and because of the maybe because of the instrument of flexible integration, as I said, there was no resonance. We have some interesting civil society initiatives. So in Germany, we had interesting discussion. The so-called New Spinelli group published a paper saying, well, we need something like a new constitution, but it was not a draft, not a clear vision of a constitutional document. And if you read what political parties all over Europe said in the last years about a European constitution, I would say you won't find too much. Maybe Volt as a new pro-European party has a clear vision, but to say it like that, a European constitution, the idea of a European constitution is at the moment not on the agenda of the European institution. It is not on the agenda of civil society initiatives, and it's not on the agenda of political parties and governments. Well, what's on the agenda then, right? And on the next slide, here are some first ideas of the new established conference on the future of Europe again. And it seems to be that the three institutions of the Council, the Parliament, and the Commission want to concentrate on European democracy in the next years. So the headline of the notice establishing this conference is "The time is ripe for a new push for European democracy." And the idea is here of the three institutions that building a healthy continent, the fight against climate change and environmental challenges, and economy that works for people, social fairness, equality, and intergenerational solidarity, Europe's digital transformation, European rights and values, including the rule of law, migration challenges, security, the EU's role in the world, the Union's democratic foundations, and how to strengthen democratic processes governing the European Union. Discussions can also cover cross-cutting issues related to the EU's ability to deliver on policy priorities such as better regulation, application of subsidiarity and proportionality, implementation and enforcement of the acquis, and transparency. Well, so far as I know, this formulation was discussed between the institution for nearly 2 years. And it was the role of the Council to stop and block too ambitious formulation. So you won't find the word constitution here. And of course, the conference should not deal with an anthem or a European flag or something like that, or European ministers. So it's not, to say it like that, it's not a mandate to work on a European constitution. It's a mandate to work on different policy fields. So I would say it's a policy-oriented approach, and it's a mandate to think about especially democratic participation in the European Union. So it's a very, let's say, functional, very down-to-earth approach now. Well, but because of this, this is another problem. The resonance is not very high. So I think when the three heads of the institutions, so Ursula von der Leyen and the others, announced this conference, they had a big online, so they wanted to have a big online event, but I think just some hundred people attended the conference, and they expected thousands and thousands. So that seems to be a problem. And maybe European people are not interested at the moment because they have other problems. So participation is a problem at the moment. So I'm at the moment organizing some events in the context of this conference. And I tell you, it's very complicated to get people on board, even students. We have a series of workshops here financed by the Conference on the Future of Europe, and we will see what happens. So to be very honest, at the moment, the outcome of this conference is unclear. And well, many colleagues say, well, there won't be a substantial next step or a substantial next idea for a European constitution or something like that. Okay, conclusions and outlook. What can we learn here? So what is the idea here? Well, I would say first, what was left from Laeken? The questions which are part of the Laeken Declaration are old but still interesting. And those questions here are that is a quotation here from the Laeken Declaration. The question ultimately arises as to whether this simplification reorganization might not lead in the long run to the adoption of a constitutional text in the Union. What might the basic feature of such a constitution be? The values which the Union cherishes, the fundamental rights and obligations of its citizens, the relationship between member states in the Union. Well, it's still actual. It's still what we have to debate at the moment. And Brexit? Well, European Constitutional Law scholarship after Brexit is a little bit at risk to lose prominent colleagues and voices. And I would wish for a broad participation of UK universities and UK scholarship in the next years. We still need the expertise, and well, it shouldn't be a German approach or just a French approach or something like that. It's still a pan-European project. Even if the UK is not participating, that does not mean that UK scholars can't participate, right? And what we need at the moment, from my perspective, is a fresh start, maybe a new text, a new proposal. And this is not available. It's interesting. In 2002, 2005, we had tons of drafts and ideas how to what a constitution could look like, right? And of course, we need a simple text. And of course, the Treaty on the Union, on the European Union, and the Treaty on the Function of the European Union is not simple. It's a long, complex document containing hundreds of provisions dealing with economic law, right? So if we talk about a constitution, we should think about the relation of some basic provisions in the text and some provisions which just, I mean, are not constitutional in a, well, more sophisticated perspective. So what should the European Constitution look like? No, we don't need a constitution with 448 articles, not a complex constitution. We need a clear, short document. And this one is not available at the moment. So that is pretty interesting to see. And why? Because the member states are reluctant. And of course, you could say, well, we have to deal with other problems at the moment. The COVID crisis, look what happens at the Polish borders, think of inflation at the moment, and so on. Of course, you always will find arguments to wait. But, well, for scholars, it's an important task, I would say, to work on this, to find solutions, to find good narratives. And we had first ideas, initiatives. Think of the speech delivered by President Macron, for example. There was no resonance. There was no open discussion in the European Union. And so the final question, and it's also a little bit the starting point of the whole debate, is it up to the Court of Justice again to deal with the European Constitution? Well, if you read some of the latest judgment of the Court of Justice, dealing, for example, with the situation of judges in Poland and some judicial reforms in Poland, but also in Hungary, you will find that the Court of Justice started to develop a new jurisprudence based on European values. So Article 2, for the first time, there is a coherent approach towards a value-based approach, to say it like that. And I expect that this value-based approach is, let's say, a kind of counter-narrative to just a rule-based approach. So it's much more than just to apply the law. It's also about the European values at the moment. And then expect that this value debate is or could serve as a starting point for a new constitutional debate in the European Union. And we will see what will happen. But it's clear that there is a connection between Brexit and the situation we have at the moment, and that we have to learn our lessons now before other member states leave. Okay, thank you very much. That's from my side so far.
Jörg, thank you very much. I hope everyone can hear me. We're just about to take the slides off. There we go. Excellent. So we've now got just about half an hour for Q&A. Jörg, thank you very much. I mean, that was a comprehensive overview of, I know, a very complicated subject. And if a dummy like me from IR can understand constitutional discussions in the way you presented them, that's a really good sign. So I'm really grateful for the breadth that you've given, but also the array of different kinds of talking points I think that we can dig into. So as I say, we've got about half an hour for Q&A. While people are formulating their questions, I'll abuse the chair's privilege to introduce a first question. But just a reminder to all of you, if there's a question that you would like to be posed, please put it in the chat function, which you can see at the top of your screen. And if you have trouble typing, if you're unable to do so, please just raise your hand and I'll do my best to call on you that way instead. For the moment, I see that there are no questions in the queue yet. I think you're all just thinking very carefully about what you want to ask. And so, Jörg, I'm going to pose a first question to you, and I've got a few. So perhaps we could start with this one, and it actually connects then to something you had just at the very end of your presentation. And you mentioned it early on, and then you kind of came back to it towards the end. And that's this sort of question of maybe perhaps the tension right now in the EU between the nominally liberal purposes of the organization and the challenges that we're finding with some, shall we say, illiberal members, particularly in Eastern Europe, but perhaps not only there. And so I suppose the question is then, how does a document like a constitution, which presumably would be founded, as you say, on sort of liberal values, liberal principles, how does it then deal with those illiberal members? Because that seems to me quite a fundamental challenge. So perhaps we can start there, and then I'll bring in other folks as well with their questions.
Well, at the moment, we have a discussion, of course, how to deal with countries. And of course, the discussions are based on some provisions of the Treaty on the European Union, dealing with members not willing to obey European rules, right? First of all, I think there's something that we can learn here. I worked in Hungary and Poland for many years, and I lectured, especially in Hungary, and had lots of meetings with Hungarian judges. After the fall of the Iron Curtain, there was no clear idea or vision what a membership in the European Union would mean to those countries, and what what it would need. I can remember I had 1 week of lectures in Hungary, and after that, so I think it was a meeting of around 100 judges. They asked me, pretty interesting what you said about the European Union and European law, but do you really think we have to apply it? So there was a total, so the governments in Poland, especially in Hungary, always told it's just about money. And I think today many countries realize that it's much more than that. That of course and it's much more than a common framework or something like that. It's a legal order with clear with clear legal obligations. And of course, all countries or members are expected to obey all those rules. So that's the starting point. So it's a kind of, let's say, a misinterpretation in Poland and Hungary what the European Union is. And I think an open discussion about the constitutional roots and dimensions of the European Union could help, because we never had an open public discussion about the future of the European Union. If you read a textbook on European law, so it's now just a lawyer's perspective, right? You will find that the last chapter says, well, the concept we are talking about is called open finality. So we discuss with people in Poland and Hungary, but also in Portugal, of course, in Germany, an institution or an organization with no clear purpose at the end, no clear final stage so far. So people can't deal with the concept. And maybe an open discussion would help to also to promote the liberal values or purposes of the European Union. Because it's still it is still a problem that many people don't understand the architecture, the complexities of the European Union. So that could help. And we need this open discussion. So if you attend meetings in Brussels, I do this sometimes for the German government. You have so many elephants in the room, but nobody talks about that, right? And so this constitutional debate or a new, fresh constitutional debate could help to discuss the European values. So that would be my first answer.
Jörg, thank you for that. We've got a couple of questions coming in, and apologies to some of you. For whatever reason, my Teams is acting up. So Dr. Peter is feeding questions to me separately because I'm not able to see the chat because the gremlins have decided this afternoon that part won't work for me. But we'll carry on. I've got some great questions in the queue now, so I wasn't ignoring those of you who had already submitted your questions earlier on. This is one from Dr. Myrna Dwyer, one of our colleagues in the School of IR. It's a bit longer, Jörg. I'm going to read it because I think it's a really rich question, and it's better than me trying to paraphrase it because she's the expert. So beginning with, thanks very much for a really interesting and highly timely talk. I find it very interesting how the heyday of European constitutional law and aspirations for a European constitution very much overlap with the time referred to in the literature as the, quote, permissive consensus, end quote, where EU issues were depoliticized and of little public salience. Now that we're in the time of, quote, constraining dissensus, end quote, of high politicization of the EU, of which Brexit might be a key example, what potential is there for constitutional development, either through treaty reform or through the CGLG jurisprudence? Has politics killed off the constitutional project, and then in brackets, for now, to end? That's a big question. I think it's a really great one. So why don't you take a stab at that, and then I have some others that I'll feed to you after that.
Yeah, that's a question. So it's again, so now it's all on the table. Well, the role of politics. First of all, let's say who is responsible for the advancement, right? For the next constitutional step in the European arena. And there is an interesting development, which I think never was discussed in detail. If you read the early versions of the treaties and see what happened in the early years of European integration, it was always the Commission. It was always up to the Commission to propose new directions, ideas, to bring up proposals, to formulate policy papers, and so on. The Council was just a kind of well, it was a meeting of the member states, right? Still, of course, influential and important. But it was always the Commission. And this changed, and I would say it was especially the German influence in the last 15 years, and the German Chancellor Merkel, who worked on a, well, undetected reorganization of the institutional design of the European Union. Because today, every important initiative
lays not in the hand of the Commission. And the White Book process underlines this, because there was no resonance. The Commission published 5 White Books. You won't find official communication of the European Council on that. It's pretty interesting. So there was no reaction so far. And now the Council acts a little bit more again. So the question is now, who is on the driving seat? And it's not the Commission, as the treaties would, well, I would say it's if you read the treaties, it's up to the Commission to make the proposal. It's now the Council. It's a kind of institutional imbalance. That's the first problem, and the member states block at the moment. So let's say we miss the supranational agent for the next constitutional step. And that could be, of course, the Court of Justice. And we know that courts are powerful institutions and so on. But of course, a court won't make a constitution. That is not possible. A court can underline the fundamental values. It could say, well, I treat the documents as a constitution, of course, and I can underline the importance of document, but it's not up to the courts. So what we would need is, first of all, we need to think about the institutional balance in the European Union, and we have to think about the driver's seat. And I don't see that a conference or a convention or something like that would be the starting point for a new constitutional debate, but we need a substantial proposal by the European Commission. We need a new era of supranationalism if we want to go that way, of course. And here's another problem. The member states at the moment, I totally agree, would block this. But there is, we don't have the intellectual capacity at the moment. We don't have the draft. We don't have the ideas. We just talk about crisis. And all the institutions discuss the crisis, the rule of law crisis. And as I said, Jean-Claude Juncker, character in the State of the Union address, said, well, we are in a polycrisis. So the crisis narratives took over for a couple of years now. And my idea is that we need, of course, a new constitutional debate. So, and of course, it can't be the same debate we had 20 years ago. The Laken Declaration, for example, if you read it, it was a clear reaction on the attacks on the World Trade Center in New York. So, of course, the Europeans were shocked at these days and willing to think about the future again. It was maybe a small constitutional moment without any result at the end, but it's pretty interesting to see. And maybe, although I don't like those narratives that we need a crisis to do the next step, maybe it will be the case, right? So we will see. But we need, let's say, we need a discussion about the institutional framework and the institutional practice, of course, because the framework never changed. It was a political practice that it's now up to the council to take all the major decisions and not the Commission. Of course, it's not the role of the Court of Justice to do the next step, but the court always reminds, of course, the member states what the next step could be. And the jurisprudence of the court in the last years is pretty much based on human rights on the one side and the rule of law on the other side. And it's because Cohn-Leonard's and some of the colleagues at the Court of Justice are very active in this field. It's pretty interesting to see. So, of course, the court is a political player, but not in the driver's seat, of course. So we need a discussion. What again? We don't. It would be our task to think about concepts. There's nothing on the table, and that is, of course, a task for scholarship and academia. In Germany, it's impossible to start a debate about the United States of Europe, people would start to laugh, right? They would say, he's crazy at the moment to talk about the United States of Europe. But there's nothing on the table. We talk about a union. We even don't know what union means in this context. I never read, it's my fault, but I never read a paper on the meaning of union in the context of the European Union. And so as a German lawyer, I have tons of commentaries here on EU law, and you would expect a clear definition of the term union in the commentary on Article 1 EU treaty, right? You won't find it because we have no legal and no constitutional concept what union means in the European context. So there's just some ideas now I can present, right?
Jörg, thanks for that. I'm going to come on to a really great question regarding Brexit specifically in just a second, but I wanted to follow up quickly with you on this point because you're mentioning, and it came out in your talk and in your response just now, that there needs to be a new era of constitutional thinking, and presumably that requires some agency, right? Somebody has to push this forward. And so I suppose what I took away from your talk in part was that there isn't an obvious state level agent. There isn't one country member that could really be the champion. But do you see any states that might be willing to take on that mantle? Maybe not immediately. As you say, there's this sort of notion that there are other more immediate crises to be dealt with. But is there an obvious constitutional champion within the EU today at the level of the state, or even
Yes.
a particular political leader?
Yes, well, there was a first attempt of Macron, right? So his first speech at Sorbonne without any reaction. I think that the new German Chancellor, Olaf Scholz, is a different player now. We had a discussion in Germany a couple of weeks, 1 year ago, when the Next Generation Europe was debated in the German Parliament. Olaf Scholz gave a fantastic speech, not fantastic, but a speech, and said very clearly, that was interesting, that Next Generation Europe is the next step towards a fiscal union in Europe. And he faced criticism overnight, of course, because it was obvious that in the German government, nobody thought that he as a minister should say something like that. The next step towards a fiscal union. The sound was like, we're doing now the next step when it comes to fiscal integration. And as we all know, fiscal integration would be a very important a cornerstone for a new constitutional movement, right? Therefore, I have no idea what the new coalition treaty looks like, but I expect a very progressive German policy in the next years. I expect a very progressive French policy in the next years, and the same applies, interestingly, to Italy. So it's possible at the moment to start a new debate, and maybe the next German Chancellor is the guy who would initiate, who could initiate a new debate. Whether this will happen, I have no idea. It depends also on the development in the next 2 years here in Germany.
Super. Thanks very much for that one. I'm going to come to a question that has been waiting patiently in the queue for a little bit from Professor Andrew Williams. And this is more specifically on the question of Brexit, and particularly the sort of the British perspective, or the relationship that you've touched on in the talk. So the question goes as follows: how do you persuade the people, in this case the British people, to take the very idea of a written constitution seriously when British people, we, are so historically opposed? And then Andy adds, but you cheered me up by showing that there is signs of recognizing that not all of Brexit is the result of narrow-minded nationalism. So thank you. So ending on a positive note that way. But given that there, and in this case, the question is specific to the British experience of an unwritten constitution, but I suppose also that this is more broadly a question of how the constitutional principles at an EU-wide level be made real to people, perhaps those that are also citizens of continuing EU members.
Yeah, that's a very important point, and that's why, and it was one of the problems of the draft constitutional treaty. You may remember that the French government sent a copy of that treaty to every French person. And if you read the document, the draft constitution today, it is obvious that it was impossible for most of the people to understand it. Again, 448 articles. So this was a kind of first bad mistake, one could say. The other side, without the consent, without the acceptance of the people, a draft constitutional treaty or a constitution, well, let's say it like it is, it can't survive, right? So it's so how could you convince people to talk about that and to accept a written constitution or a new, let's say, a new document, right? Well, I wouldn't say, and that's the problem. Or was the problem at these days? It was a very fast procedure, right? We had a European convention without too much public discussions. It was some senior politicians worked together, and the result was a draft, which was, of course, discussed in the European institutions, but we had no public discussion. Why? It was impossible to discuss about this text in public, with the public, because it was too complex. It was very technical. Why should you discuss provisions dealing with competition law, energy law, or tourism, or whatsoever with people who never heard about that? That makes no sense, and that is the first lesson I would say we have to learn is we need a short text proposal, 50 articles, something like that, with a clear language, addressing what people really expect, or we must address what people really expect from a constitution. So that would be, what institutions do we talk about? What are, of course, the values? And what does the concept of values means in the European context? Separation of powers, so institutional balance, something like that. So some basic principles, right? And of course, fundamental rights. To say it like that, I mean, the Court of Justice became a very important fundamental rights actor in the last years, especially because the third generation fundamental rights, so data protection and so on, bioethics, something like this, are so important now. And the Court of Justice is very good when it comes to new dimensions, technical developments, and so on. So fundamental rights on the European level will play a very important role in the next years. And so the resonance for this could be a different one. Because a German would say, why do I need European fundamental rights? I have my basic law. I don't need fundamental rights on the European level. It's good for nothing. But today we have a discussion, is the basic law still up to date, right? Do we need a fundamental revision here in Germany to deal with digital rights and something like that? And that is maybe a European discourse. What about climate protection, for example? We don't have a fundamental right dealing with climate protection so far in Germany. On the European level, we have many provisions dealing with climate protection. So, and it's obvious that Germany can't protect the climate alone, right? As the UK can't and other states can't. So I think people would understand, especially in the context of climate protection, especially in the context of digitalization and digital rights and so on, that we need more than just a domestic or national constitution, but we need a clear, concise, short framework to deal with all those challenges. And that's why I'm a little bit optimistic, not for today, not for next years, but maybe within the next 10 years, we could have an open debate on this.
That's a very optimistic note to almost end on, and I'm going to leave you with one really excellent but challenging question that we'll do just in the final minutes that we wrap up. And apologies to those questions that I wasn't able to get to. This is from another of our colleagues, Professor sorry, Filippo, I almost promoted you accidentally, Dr. Costa Buranelli. You'll get there soon, my friend. This question, and this is another one that comes with a lot of praise for a really fascinating and timely talk. And this is, I think, a really great way to end, actually, because perhaps in some way it brings us kind of back to the beginning, which is, it's often said that a precondition of a constitution is the presence of a demos. And is there for you then a European demos? If yes, who's part of it? And what role could it play to foster a bottom-up process of constitutionalization? So naturally, we've spoken quite a bit about institutions, and one of the questions I prompted for you was, which states or state leaders might be most important in a renewed constitutional process. But I think Filippo's question is a great way to end us by bringing it the other way around. Do you think that there is something like a demos now, or the one that could be developed that would help to build the kind of constitutionalization that you're advocating for, or would like to at least see discussed?
As a lawyer, I can't say that. I don't know whether it's possible to develop a demos. For us, a demos is you have a demos or not, right? But of course, that's a very important question, and I think that the younger, especially the younger generations, are much more open-minded when it comes to a constitutional process on the European level. A generation which is used to to study abroad, to travel in Europe without restrictions, which is used to one currency, is of course much more open-minded than a generation after the World Wars. Of course, it's a total different story, right? And it's a generation now. I mean, we talked about civil society movements and so on. Here in Germany, Fridays for Futures. Generation concentrating on the future, not only on climate change, but here in Germany, for example, but also in Scotland, of course. If you talk to students, there is a new, I would say, a new openness for future topics, and maybe that could be a very important basis for the next steps. Is there a demos? Well, that's I would say a very German question at the end, because the Germans think that there was something like I don't know, 50,000 years ago, some Germans came from heaven, and everybody has its roots and finds its roots from these first Germans, right? And it's the constitutional thinking in Germany that we need a kind of not only a demos, but it must be a German demos, right? That's a very problematic approach, I would say, but it's still very important here in Germany. And it's if you read the judgment of the German Constitutional Court, the question is not who is living in Germany, but the question is always who is German, which is, of course, a big difference, right? So participation rights and so on depend on citizenship, which is, of course, everywhere the case, mostly in Europe, but anyway, the Germans are, of course, to say it like this, are very German. And what does it mean? It means that we really believe in those identity concepts, or many people believe in identity, that without a common identity, it is not possible to constitute a demos, right? So, and this is, of course, and now we know many countries in the world which could not survive if identity would be the most important feature of a demos. So demos is maybe in the European context something, of course, we should concentrate on. I think the European citizenship is one important cornerstone. I think the openness, the future orientation of younger generation is another important cornerstone. And I think, again, new concepts. So without identity and all those ideas that we are kind of that a society is a kind of tribe relation, people, something like that. But more we need modern concepts, and of course that is another point to debate in the next years. So what demos, what means? Do we need it for a European constitution?
Well, that is a really fantastic answer to a complicated question, and it leaves us, I think, on an optimistic note. So I want to thank you for that, because it's not always the case that we can end on an optimistic and forward-looking note. So let me say that we could have, I think, carried this conversation on for longer. I know that there's at least one more question that was fabulous that I couldn't get to, and I'm sorry for that. Let's take this as a to be continued, because Jörg will be joining us again, both online and thankfully in person in the new year, both with the CGLG and the ILCR and in other places as well. And so we'll be sure to be advertising those initiatives as they come along. For now, Jörg, I want to thank you so much for a really fantastic talk. It was superb to be able to get your perspective. Thanks as well to our audience and the excellent questions. As always, the most important thank you in a sense is to Jenny Haley for making everything work, our tireless events and administration coordinator. She is fabulous. Thank you, Jenny. Jörg, thank you so much. We look forward to hosting you again in person in the new year. For now, that's all for us. Thank you again. Thanks, everyone. Have a safe evening and goodbye for now.
Thank you. Thank you very much.
Thank you. Bye-bye.